When our children are at schools, the schools step into the position of the parents. It's a Latin term, in loco parentis, that they take that role of being the parents. We expect schools to be vetting their teachers. We expect them to have policy related to relationships. And we expect schools to have the appropriate culture of oversight, meaning that it's not just look away or not just that teacher's just a bit goofy. No, we expect our schools to be a place where our students are safe. We expect them to be vigilant. We expect them to be looking out for our kids' best interest. In Washington, there are two legal theories, or there are two ways schools can be held liable for sexual abuse of students. The first and the most common is negligence. Did the school fail to adhere to the standard of care? Were they being reasonable? That most specifically comes down to two different things. Number one, did they have notice? Were there things that they knew about that they should have acted on? Did they know that this person had a past that shouldn't have been overlooked? Were they properly vetted? Were they there when they were supposed to be there and interacting with the students they were supposed to be interacting with? Failing to adhere to the standard of care, failing to be reasonable, failing to protect our children, all of those things can lead to a successful claim of negligence. Beyond negligence, schools also can be held liable for discrimination for sexual harassment. That includes sexual abuse. So in 2020, the Supreme Court of Washington agreed unanimously that if students are abused in schools, that equates to sexual discrimination, which in turn is a claim for discrimination where you can recover for all of your damages. That means attorney's fees. That means costs incurred. In Washington, you can be held liable for negligence, which is failure of policy, and also be held liable for discrimination, which is a completely different standard and opens up many more remedies for victims. The difference between a negligence claim and a discrimination claim is what you're required to prove. So in a negligence claim, a school has to have notice or bad policy. When it comes to a discrimination claim, it's completely different in both what you have to prove and also the remedies available. So when the Supreme Court said yes, sexual harassment or sexual abuse of children equals discrimination, what they were saying is that schools are liable for the conduct of their employees in no different way than if a truck driver was out driving for an employer and they hit and hurt somebody. We would say that that employer is liable. The same now applies, fortunately, to schools, that if a student is being sexually harassed or sexually abused, that they are strictly liable, that they have a right to a remedy of both their damages, their attorney's fees, the costs, which is different than what you may get in a negligence claim. And the reason that's so important is that the Supreme Court says you schools are acting as the parents. You need to implement proper policies. You need to implement proper vetting, proper protocol to protect these students. And if you don't, and children are abused, you're responsible. We're not going to put that burden on the parents to prove different elements. You're liable, just as any other employer would be liable in Washington.